ಇದೆಯಲ್ಲ ಸರ್.
Slide showing.
ಮಾಡಿದ್ದೀನಿ ಸರ್.
Yes. Good afternoon, everybody.
Good afternoon, sir.
Good afternoon, sir.
Good afternoon, sir.
Very good afternoon, everybody.
Good afternoon, sir.
Good afternoon, sir.
Very good afternoon. And last time a question was asked to me: common laws, French laws, and Latin American laws. Common laws are those laws where the judiciary interfere by way of judicial review of the law and also the interpretation of the law. So this means whatever the decisions are taken by the highest courts are known as the law of the land. The French laws are normally the Napoleon Code, Civil Code. Actually, Napoleon Bonaparte is not famous for he ruling the Europe. He is very famous for codifying the laws relating to administration, then legal issues, then commerce, then industrial policy, international policy, everything. For that codes, they are also known as Napoleon codes. They are very famous. They are the landmark and benchmark in conducting or taking any decision on different issues. So normally these Napoleon code are used in some European countries, some African countries, normally where the French ruled. And Latin American laws are those laws mixed with Portugal laws. Portuguese and the French, they are mixed, but they are in preferably southern South American countries. And what happens? These laws, other than common laws, these French laws and Latin American laws do not accept the decisions of the court as the law. This is the major difference between common laws, French laws, and Latin American law countries. And India is a common law country, and many of normally we borrow most of the issues from American Constitution, England, British Constitution. No doubt, British Constitution is an unwritten constitution. We borrow many things from American Constitution, Russian Constitution, Switzerland, Ireland, Canada, and this that separate this one. This is about the Latin American laws, then French laws countries, and common law countries. Then where did we stop yesterday? It seems we had covered the Income Tax Act and Indian Penal Code. Now we start from the Indian Patent Act. I hope you are all professors and you have a zeal to conduct inventions, research, and also you encourage the research. Under such circumstances, you may come across different type of new inventions. So for that, you can register under the Patent Act. This governs the rights in India administered by the Officer of Controller General of Patents, Design and Trademarks. 20-year term market exclusive qualifying inventions. They must be of excellent and unique research you must do. See what they only will be recognized and given the patent. And you will, whoever uses those formulas or those issues, they have to pay the royalty to the person who have invented it. So key patentability requirement: to qualify for a patent, an invention must pass the triple test. 3 tests it has to pass. Novelty: the invention must not have been published in any document or used anywhere in the world prior to the priority date. It must be part of the state of the art. That means unique. Then inventive step: the invention must feature a technical advancement compared to existing knowledge that is not obvious to a person skilled in the art. See, we have a good number of artisans in villages and different places. They exhibit different type of arts, different type of mechanisms. Normally, we Indian jugards we call. In India, we have numerous jugards. Those are against the scientific base, but they work. What we need is working. We don't bother whether it is scientifically proved or not. Jugards, many jugards, and India is known for creating numerous jugards. Industrial applicability. So it must create the employment. It must generate the wealth. Mere giving any research or PhD work, it is not a patent. You cannot have the patent for that. So what has happened? I mean, capable of being made use in an industry. It is industry. Majority is industry. That means ultimately it must generate the employment. So non-patentable subject matters. Under Section 3 and 4 of the Act, certain innovations are strictly excluded from patentability to prevent monopolies on the basic principles and traditional knowledge. It prevents evergreening plan patents by barring patents of new forms known as substances unless demonstrate significantly enhanced efficiency. It is not a patent. It excludes computer software per se, mathematical methods, business methods, and patentability. They are not covered in the Patent Act. Prevents the patenting of traditional knowledge. Prohibits patent for inventions relating to atomic energy. So there is no patent registration for the atomic energy invention. I want to share one example. America claimed the patent over Indian neem, turmeric, and tamarind. So it was fought in the court by the Indians. Whatever they did made inventions in the laboratory, they were already mentioned in our Ayurvedic system. So therefore, India could win the case. Therefore, otherwise, had they been patented, would have been very difficult for us use to tamarind other turmeric powder every day in our kitchen. For every spoon of using the turmeric powder, we had to pay the royalty to the American institution. So thanks to our people who fought in America, as far as neem, turmeric, and tamarind, and there are good number of essences also where it has been mentioned in Ayurveda. So like that, it is Indian Patent Act. See, mere a small research work, it cannot be made as a patent. It must be of applicable to mass, and it must help in mass production. So that is the Indian Patent Act. Yeah. Whoever, or if your students or you are interested to conduct study, keep it in mind when you make any new inventions which are useful for industries. You can claim the patent under the law. So Prevention of Corruption Act. Many a times the government officials, recently I saw in the paper that 8 people have been raided their house and they amassed wealth like that. So Prevention of Corruption Act 1988 that came into existence in India. Any public servant obtains or accepts or attempt to obtain any person's undue advantage with intention to performance of public duty improperly or dishonestly or to forbear or cause forbearance perform duty either by himself or by another public servant. Normally what happens, see, many a times innocent people are made as scapegoat. So one must keep in mind when it comes to the court, they ask whenever any public servant asks for money, the case must be pending with him. If the case is pending with somebody else, if he asks the money, it is not booked under the Prevention of Corruption Act. He must demand. So for the demand, one has to produce the documentary evidence. It may be electronic also. Normally, they don't give in writing, you give that much this much money. There are some instances I have seen that the officer used to give in a small sheet the number, amount, and that was given to them. And to that amount, they have to pay. It seems in some of the government offices also it is going on. So therefore, one must demand that must be documented either electronically or otherwise, and must accept mere demand of money is not sufficient to book a person. He must have accepted it. See what happens sometimes to scapegoat anybody or to harass anybody, the people will come with the money and put that money into the pocket of the person. Such things, so many things have happened. So if he do not touch, if he do not touch, is forced to touch, that the accused have to present before the judge and tell the judiciary that has been harassed or it has been given with a threat. So therefore, the Prevention of Corruption Act, these are the ingredients. It obtains, accepts, attempts to obtain undue advantage. It may be cash or kind, not necessarily in cash. If you receive gold, it is also in the form of money or cash. Reward for improper and dishonest performance of public work, forbearing perform such duty either by himself or another public servant. It performs, induces another public servant to perform improperly, that influencing. Yeah, you do this, then I'm going to give this money. Or some government officials may work as agents also. Even if the person demand money from the agent also. If you go to some of the government officers, he asks to contact the particular agent. And if you go and contact him, your work will be done. But the question is whether corruption is sustainable, or can it not be wiped out fully? It is very difficult. Because in Kautilyan Arthashastra, long ago, maybe 3000 BC, 300 BC, the Kautilyan model of administration is known as centralized administration. And the government departments were functioning, more than around 18 departments like that, different sections. And he has made a statement. As and when there is an administration, there is a corruption. As long as there is a water, there is a fish in the water. If you see in the broader perspective, wherever the water is there, the fish is there, we don't know how much water it drinks. Like that, in the in the water of administration, officers are like the fish. We don't know what quantity of water they drink, or there are good number of honest officers who do not take anything. They are also there because of the society characteristics like that. So therefore, as long as the administration is there, corruption is there. And one of the famous political thinker, he said, power corrupts and absolute power corrupts absolutely. So like that, in government of in India, we have Prevention of Corruption Act, which one must keep it in mind, and it is for your information. This is there. So Protection of Civil Rights Act. Next comes the Protection of Civil Rights Act. So actually, this has been enumerated in the directive principles of state policy. The oppressed, preferably or major, the scheduled caste and scheduled tribes, they were oppressed over the years in the name of Veda, in the religion. They have been declared as untouchables. In Veda, there are not 4 varnas, there are 5 varnas. Then the fifth one is called Panchamas. But there is no Panchamas in Indian society right now. Normally we declare that Brahmana, Kshatriya, Vaishya, Shudra. Panchama has a different definition in Veda. So Untouchability Act has been bought. Practicing of any untouchability is a criminal offense and it is punishable under the law. See, I want to share one example of Marathas. You must have heard Bhima Koregaon. Anybody of you have heard Bhima Koregaon? Bhima is a river in Maharashtra. Koregaon is a village. Koregaon is a village in Maharashtra. Bajirao of Maratha ruler, he made a law. Any scheduled caste person must not enter the village in the morning or in the evening. He must only enter the village when the sun is in the middle of the sky. And when he comes to the village, he must tie broom to his back, because his steps must not spoil the purity of other caste people. Means that broom must sweep his steps, footprints, it must sweep. Then he must tie a pot around his neck. He must not spit. If at all he want to spit, he must spit on the pot. So these are the situations existing. Why I am quoting this example is how we made the one person from this village, Koregaon village, go to Bajirao and tell him that we don't have interest to support the Britishers, but you must treat us equal. If you treat us equal, we are going to fight for you. The Bajirao says, no, I am not going to accept you as equals. Whatever you want to do, you do. Believe it or not, only 600 people with a passion for equality is known as Meher Regiment. Later on, it was dissolved. Later on, once again, it was reinstated. Meher Regiment, 600 people, killed more than 4,500 people and bought the war in favor of the Britishers. Therefore, that became the end of Maratha rule in Indian context. And I want to share, had we been followed Basavanna in the 12th century AD, there would not have been any surrender of Indian territory to any foreign invaders. So therefore, equality before law, the Protection of Civil Rights Act, it criminalizes practicing of the untouchability among the society. And therefore, it is a bad the practices we followed, but the society accepts it. What as educated people, we must not practice. We must, I know you are all treating equal everybody before the law because we are all educated and all. So the disability, you must not treat them, this one not allowing them to the temple, then denying access to shops, restaurants, hotels, and public entertainment. It is really pain to me when I heard in recent day the Shudra person went to barber shop in a village and he was beaten. So the law is very strict now, and if you go and file a complaint, they will be put into the trouble. Then basic services and amenities like refusing admission, barring individual from hospitals, dispensaries, educational institutions, refusing services and goods, denying sale of goods, rendering of professional services, discrimination of violence and forced labor, especially in mining, some granite and all, they used to bring the people from outside state and they used to work around the clock and they never properly handled the given food and all. Those were also booked in the Chamarajanagar area and all. Molesting, injuring, obstructing persons from existing their civil rights, preaching directly, indirectly, inciting, encouraging practice of untouchability, unlawful labor, compelling someone to perform jobs such as sweeping, scavenging, and removing carcasses. So these are the provisions of the law one must not practice. The question arises, see, sometimes it is an allegation that the scheduled caste and scheduled people, innocents will not misuse it. The miscreants misuse the Protection of Civil Rights Act. And a good number of judgments, Supreme Court judgments have come. Now, if at all anybody address him with the cost, it is a punishable offense. It is cognizable offense. Police can arrest without warrant. So in other cases, they must have the permission from the court. Otherwise, they can arrest. But recently, the law has been changed. The addressing of untouchable must be in public place. If the interaction takes place, the argument takes place in a room, it is not covered under the Protection of Civil Rights Act. And there must be a witness of other causes. 4 people must say that this person has used that word against this person. So these are the recent developments in the Protection of Civil Rights Act. So because of that, that has been a little bit reduced. The tension has been under misuse has been reduced. In recently one media, public media, one person spoke on the TV that alligating the particular community, and he was put behind bars. The case has been arrested against him. And recently there is also an amendment that the person who is affected by misuse of such act can also file a complaint against the scheduled caste and scheduled tribe persons. What I mean to say is, unless we respect each other individually, this is very difficult to implement in total. So next comes Consumer Protection Act. So till end of this century, the consumer was a neglected part. I tell you, I have an experience. When I went to a hotel long ago, probably in the year 1980, if I asked for extra chutney, the hotelers used to charge extra. So after advent of the World Trade Organization, that liberalization, privatization, and globalization, because of this policy, the consumer grow like Anjaneya. There is no end. Such a big powers the consumer got. So if you go to hotel now, they will ask you, sir, what you want. If that is not there, they will arrange to get you. And earlier, when you to talk to the supplier, they used to say, sir, if you are interested, you take, otherwise you go. Now they don't like that. They don't say like that. Sir, sorry, sir, we are going to arrange. Or sorry, sir, we don't have this one. This is the beauty of Consumer Protection Act. It is a result that has given the strength, and the consumer is the god. Any this one in all the fields, whoever is your client or consumer, they are your god because they are paying masters. We have to respect their rights, and they have every right to get the complete satisfaction. I want to share one example with you. I had been to England. You know that during that period, probably 2000 I had been, there was no Indian hotels at that time. There was only hotel in London in South Hall Street. We had to drive more than 25 kilometers to go to that hotel. So when we went to hotel, my teacher told me, don't hesitate here to ask any question to the hotel owners or suppliers. You can ask, what is the quantity I am going to get? Whether it is allergic to any of the issues, any allergic items. And what are the ingredients in that? See, I may order. If I don't like it, it's waste. Therefore, from that day onwards, then, and in European countries, if you ask such questions, people don't think otherwise. In India also now, then whenever we go to a hotel, then if we ask for any item, we ask what it contains, how many pieces I'll get, whether it is having spice, if it is having spice, how much spice, whether it is going to relish and all these questions you can ask. This is the beauty of outcome of the Consumer Protection Act. So consumer protection, not necessarily in hotels, anywhere, any services. But unfortunately, this act is not applicable to the medical doctor, medicals. But hospital services you can ask, but not for the doctor, and not for the even advocates also. Because it is a profession. If you are interested, you can go to them. Otherwise, no. So like that, there must be a service, but it is applicable to real estate agencies. If the real estate agent have taken money from you, if he has not given you the site, you can go to the consumer court and get the orders against him. So like that, if you purchase one item, if it is not meeting the quality and quantity requirement, you can go to the court and get the things done. I want to share one example with you. One person board the bus. In between, he get down and he went away. Then the bus went off. Then he filed a case in consumer court. The consumer court awarded the penalty on KSRTC and made him to pay the losses and damages happened to him. So the Consumer Protection Act recently changed landmark legislation enacted safeguard the consumer rights against exploitation, defective goods, poor services. It provided accessible low-cost redressal mechanism through dedicated three-tier quasi-judicial system. We have district consumer forum. Any person affected by the deficiency in services, he can approach the district consumer forum. There is a forum in all the district. There is district consumer forum. You have to file an application up to 20 lakhs. You need not have to pay any fees to the consumer court. After 20 lakhs, you have to pay minimum amount as a fees. So like that, in all the districts in India, there is consumer forum. And we have state consumer forum, handle up to 5 crores. Then we have central central consumer forum, it has unlimited money. So like that, the hierarchy of the consumer courts are there. They are quasi-judicial system. One person will be from social system or the administrative system, and one person compulsorily from judiciary. There, two persons will be there in the court, and they will give the judgment. The consumer rights, the objective is established 6 fundamental rights: consumer safety, information, choice, representation, redressal, and consumer education. It merely not establish the court, it also give the education, enlighten the people to have their rights fulfilled as given in the judicial system. The protection defended buyers against unfair restrictive trade practices and hazardous goods. See what happens, whenever you make an order online, if it do not meet the requirements, you can send it back. Nowadays, they are having the program, no? If you don't want to use that one, you can send it back, return within 3 days like that. There is a provision. It is mainly because of the Consumer Protection Act. Then redressal created a specialized mechanism for resolving consumer disputes without excessive court fees. Redressal machine, three-tier system. And for your information, you need not have to hire the legal services or lawyer. Directly, you can go to the court. Even you file the case online. Only thing, you must have some procedure. And if you go to their website, they will tell you what documents you have to give. If you give that document, certainly the consumers court are 90% cases are in favor of the consumer. So like that, this is the best weapon for the consumer for having paid the money to consume particular good or services, avail the particular services. So it is a beautiful and good weapon for getting the satisfaction for the payment what you have made. So district forum up to 20 lakhs, then 20 lakhs to 1 crore, state forum and national commission 1 crore and above. Then legacy 1986 was formed, but later on 2019 a lot of changes have been made in the Consumer Forum Act or Protection of Consumers' Rights Act. Then public interest litigation. See, actually, this is the 1970 and 80. They are known as judicial activism system in India. Earlier, the Supreme Court used to just keep quiet whatever the government or whatever the people take decisions and all. And for your information, nobody was allowed to file a case on sufferers or the person who have underwent losses. So, Public Interest Litigation Act was passed in India, legal mechanism following citizens, public spirited organizations to approach Supreme Court or High Court, protect rights and welfare of the broader public, and it ensures justice accessible to the marginalized and combats systematic violations. And originally it was done in the year 1980. It gives the right of locus standi. That means in Kannada it is right to interfere in between. ಮಧ್ಯ ಪ್ರವೇಶಿಸುವ ಹಕ್ಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡ್ ಮಧ್ಯ ಪ್ರವೇಶಿಸುವ ಹಕ್ಕನ್ನ ಅಂದ್ರೆ ಯಾರ್ದ ಪರವಾಗಿ ಆನ್ ಎನಿಬಡಿ ಬಿಹಾವ್ ಒನ್ ಕ್ಯಾನ್ ಫೈಟ್ ಫಾರ್ ದ legal rights. So jurisdiction can be filed directly to the Supreme Court under Article 32. I was discussing about the original jurisdiction of the case. And for your information, public interest litigation can be filed only in High Courts and Supreme Court, not in the district level courts. Because the High Courts and Supreme Courts are unique. They have unique powers. As it is said, Article 226, that filing the writ petition, writ of mandamus, writ of habeas corpus, quo warranto, and certiorari. These are the 5 writs powers given to the High Court. Nowhere you can file the writ. These 5 writs. But you can file writ petitions, all original suits. You can file suits till the district level courts. We have junior courts, senior courts, and district level courts. You can file suit in the lower courts, but writ petition, it is only High Court and Supreme Courts. And in while discussing the powers of the court, whatever the decisions are taken by these courts, they become law. And the principle is called ratio decidendi, that the decision taken in one case must also applicable of the same situation in another case. These cases or ratio decidendi cases are applicable only on the judgment of High Courts and Supreme Courts. Then jurisdiction can only be filed directly in the Supreme Court and in the state High Court. And for your information, the public interest litigation will not go to single bench. It must be filed before the Chief Justice of that state High Court or Supreme Court. They are only authorized to verify whether they can accept the public interest litigation or not. Then only it is allowed to conduct the process, then judgment is given. Otherwise, they can dismiss suo motu or on the prima facie. Recently, one person had filed a public interest litigation against the Chief Minister of Karnataka that in while forming the cabinet in the constitution, it has been said that minimum this percentage of ministers must be there, but the present Chief Minister has taken sworn oath only with the 12 ministers. Then the Chief Justice of Karnataka reprimanded him and fined him some 50,000 rupees. You cannot come to the court with the trivial or unnecessary harassing the people. So public interest litigation, one must be very careful while filing. Then what are the items you can cover in the public interest litigation or environmental protection and pollution control? If some company is making pollution, you can go and file a case against that company because it is spoiling the life of the common people or even animals and birds and all. Human rights violations, marginalized bonded labor, prison reforms. Then consumer protection, road safety, and public health. Especially, I want to share one example with you as far as road safety is concerned. One person filed a public interest litigation in Supreme Court. See what happened earlier. Whenever the accident takes place, no person was ready to attend to him. And no hospital was ready to give him treatment, mainly because the police used to come and interrogate the person and the hospital and make their life miserable. Then he brought this issue before the Supreme Court, and now the Supreme Court and the law has made that anybody who attends the accident person, he must not be interrogated. He must not be asked to come to the police. And it is the primary responsibility of the any nearby hospital to treat him. Either you give him first aid treatment or fully treat him, they can charge, but they must not be asked to come and appear in the court. It is purely the statement given by the injured or the other person, whoever complains, and these people must not be harassed. See, that's how the public interest litigation help the life of the people more comfortable. Otherwise, had there been such a law, nobody would have come to the rescue of the injured person on the accident spot. No hospital would have come forward to treat. Now they are made it that it is compulsory on any hospital to treat the person. So like that, it's mainly because of the public interest litigation filed by one Rao in Delhi. So like that, even public health, especially in Corona time and in Chamarajanagar, some people died during Corona time because of oxygen and all. They also can file the public interest litigation like that. Corruption and maintenance of government accountability, yes. See, if you are not happy with the particular system, which is going to spoil the systematic administration, you can file a case. And recently, online filing, especially e-Khata, was a headache. And the authorities used to harass the people like anything. Now it has been made online. And that accountability, such a type of issues also be taken in the public interest litigation. So gender equality and prevention of workplace harassment. Especially, I want to quote an example, the workplace harassment, Vishaka versus Rajasthan. In that case, it is also public interest litigation. That lady filed a case for having harassed particular women at the workplace. So that next I can cover more items as far as workplace harassment is concerned in the Prevention of Sexual Harassment Act, POSH Act we call it. Then I will cover it. So this is about the public interest litigation. Anybody interested, they can, and not necessarily you can hire a lawyer. You, with the permission of the court, you can plead the case. So like that, public interest litigation gives the citizens of the country to plead the grievances of the oppressed on behalf of them. So who can file? Yeah, any Indian citizen, a non-profit organization, even NGOs. However, the petitioner must prove they are acting bona fide. Yes. See what happens in Right to Information Act, there is a provision to ask for the information. That covered in the next slide. The people, the so-called the RTA workers started harassing the government officials. So therefore, whenever you file a public interest litigation, your interest must not be there. It must be common interest and bona fide interest in good faith for the betterment or benefit of somebody else, not for you. Like that it is there. Supreme Court has established strict guidelines for filing a prevent frivolous petitions. Yeah. For small issues, they used to file the public interest litigation, as I told you, against the Chief Minister of Karnataka. And many of the cases are dismissed in the initial stage, not hearing and all. So if a petition lacks public merit, the court can impose heavy cost on the petitioner. The petitioner must draft a writ petition out to and the legal or fundamental rights being violated. Detailed guidelines and procedures for the Supreme Court are available in the Supreme Court rules. So anybody has interest in to make use of this law, you can go to the website and study the process in the public interest litigation. Yeah, next come Rights of Persons with Disability, RPWD Act 2016. The Rights of Persons with Disability Act 2016 ensure that equal rights, discrimination, non-discrimination it is, accessibility for individuals with disabilities in India. It recognizes 21 categories of disability and provides enhanced educational quotas, employment reservation, and specialized support. Expanded disabilities increase the recognized disability from 7 to 21, adding conditions like attack victim, acid attacks. Yeah, the public disability persons with a disability are also the public acid attack victims are also considered as persons with a disability. So specified learning disability, Parkinson, thalassemia, and hemophilia. Reservation in educational and this one information, non-discrimination in employment, transportation, and public facility. I want to share one example. In Montreal, Canada, there is a transport corporation. They operate public transport for the common public. And in that, they have reserved one seat board membership for the physically challenged person, because this person can put forth his grievances before the board, and he made the corporation to make the laws which are comfortable to the travelers or the physically challenged. I want to share with you, there is a law we have to provide entering into the bus and coming down from the bus, some sliding this one door. They have to open, and the physically challenged person can come with a two-wheeler, that wheelchair, and enter into the bus like that. But it found very difficult. So therefore, it has been left out like that. So rights of persons with public disabilities, there is a law. And if the person is having more than 40% disability, they are called as the Persons with Disability Act. And I want to share one information with you. Any of the government employee or any of the employee working in private organization, if he sustain disability at the time of working, suppose if he loses both the hands, if he loses both the eyes, if he loses both the ears, and if he is non-curable leprosy, suffering from non-curable leprosy and mental illness, the government cannot, or any organization cannot terminate the services. Recently, I handled one case. One officer who is a class 2 officer in KSRTC, she just joined the services. After 10 years, she was not transferred, she was made to awaiting for posting. For how many days? 1 year without salary. She was coming to the office and going back. After that, she was transferred to Gulbarga from Bangalore. During this period, she was having mild mental illness, and that became schizophrenia. And she was dismissed from services within conducting inquiry within 2 sittings. Then I plead before the judge, sir, what is this harassment? And now we are waiting for the reinstatement of that lady. What I mean to say is, the persons with disability cannot be dismissed from the services. But in our case, the people who don't want to go on duty on line, driver or conductor, they want to have light duty to sit in the depot and make some work. They bring false certificate that they are suffering from this one and all. We send them to board. There is a district medical board. They will verify experts and give the certificate. And keep it in mind that more than 40% disability, if there is, the persons must not be terminated from the services. The question arises, how to take care of them? Yes, if there is no vacancy, the government or any organization have to create supernumerary post. Till his retirement, the post vacant will be there, and after that, that will die along with his retirement. So this is the rights of persons with the Disability Act, anyways, given by the Government of India. Then right to equality and dignity, guarantee of life with dignity, protection from inhuman, cruel treatment, and protection against abuse and violence. The physically challenged person must not be abused, and they must not be ill-treated, and they must be protected, and they must be protected from the violence. Accessibility, even there is a department for that. Physically challenged persons, there is a department in Government of Karnataka and Government of India. It requires barrier-free access in all public buildings. You must have seen in almost all the government officers, even private officers, create that panel to enter into the office with the wheelchair. Then information and communication technology also, they can be easily accessible to them. High support needs provide specialized assessment mechanism and support for individuals with benchmark disabilities who require significant assistance. And it is said that the persons with physical disability, they are the real workers in the industrial experience. What it is said that they will not go on strike, and they will not demand extra, and they are sincere and they do their duty without telling them. So not mean to say that other people don't work, but it is opinion of the many of the industry owners that these people work honestly to their satisfaction and all. Then access to justice and voting, ensure courts and legal processes are fully accessible and provide for supported decision making and guardianship when necessary. Implementation in government, central and state advisory boards. There are boards established to advise central and state governments on disability policies, monitor and execution. Mere advice is not there. They have to monitor, they have to manage, and they have to execute the act. Then grievance redressal requires appointment of grievance redressal officer in government and private establishment. See, there is in POSH Act, there is a committee like internal consultation committee like. So for these people also, there must be an officer specially here and settle the grievances of the physically challenged people in government offices. So penalties is strict penalties, including fines, imprisonment for offences such as violating the act, abusing person with disability, or using derogatory language against him. See, unfortunately, for having disability, people tease them. It is not correct because every person is the creation of God. If at all we criticize, tease them, we are teasing the God himself. Then next comes registration of births and deaths. Under registration of birth and death, 1969, the act was passed. But we see the census and other things in Kautilyan administration. And later on, the Britishers who bought that census system in India. And the Indian statistician Mahal Nobis, who is known as father of Indian statistics, he brought a lot of changes in Indian statistical system. Therefore, we have Indian Statistical Organization, National Sample Survey Organization, and even census are also conducted because of his the contributions given to the Indian system, administrative system. So even stillbirths in India are to be registered within 21 days. The registration is mandatory, prove that, and that the place of birth, death, legal purposes such as obtaining passport, Aadhaar cards, and processing the proprietary claims. See what happened many a times the birthdays are fixed by the primary school headmasters, many of the students. Now it is not there. Our time, when we went to the school for admission, the teacher asked me to touch my left ear with right hand. Then if it touches the ear, he is considered as 6 years old. He got admitted. And majority students' date of birth is 1st June 19, whatever number is there. Therefore, you will see in government departments, majority people retire in the month of May and June. So now it is not like that. It is everybody is very intelligent and educated, and they know the rights of the registration and all. Now it is the act which mandates that everybody must record the births and deaths. Where to register? Event must be registered at the register office in specific jurisdiction where the birth and death took place, not where the family resides. It has to be registered in the place where the birth took place. Then who can report? Not necessarily. See, when you go to any hospital, it may be a private hospital or government hospital. If the delivery is taken, delivery is done, they will inform concerned authorities. In Indian context, all the municipal authorities are the authorities to register the birth and deaths. They will inform. Later on, we have to go and claim the birth certificate. If you have named the child, you can make a mention of the child name. And if not, you can, within 1 year, you have to make a mention, give the name of the particular child who has taken birth on particular date. Then at home, head of the household, nearest relative, or the oldest adult person present must report the event. If the delivery has taken place, in many a times, the delivery in village side take place in the houses. They have to inform the village accountant that, or they have Grama Panchayatis now, right now. They can go to the Grama Panchayat and tell them that the birth has taken place in our house. Then fees, if they inform more than 21 days, up to 21 days free, 21 to 30 days small late fee, rupees 150, that depending on the state. Then 30 days to 1 year, you have to take permission, written permission from the Tahsildar and Commissioner to make entries of the date of birth. Then 1 year requires court order. After 1 year, if you go and tell that the birth has taken place in our house, you have to take permission from the court. Otherwise, it will not be registered. So therefore, it is very important, and it is required for everybody admitting the child to the hospital or some educational institutions, taking passports and Aadhaars and bank account opening, everything. The date of birth is very essential, and it is the law make mandatory for every citizen of the country to register the births and deaths. The register must provide a physical and electronic extract in the entry birth and death certificate free of charge. There is no money for this. Up to 10 certificate they will issue free. If you ask more than 10, they will charge. Even that also they must not be charged, but they'll charge because paper fees you have to pay like that. They give up to 5 to 10 certificates, they will give free of cost. And there is no money for that. After 1 year, the Tahsildar or the court, they will fine and make you to get registered. The register must provide physical, okay. Then the national database and amendment. Amendments require medical institution to issue cause, death of certificate to register, mandate use birth, death certificate for official identification. It also enables the Registrar General to maintain centralized national database. And deaths also, immediately if a person die in hospital, the hospital authorities will inform the municipal organization, and they will also inform Food and Civil Supply Department. If they have taken ration card, they have to be cancelled. And nowadays, I don't know to what extent in Grihalakshmi, recently Karnataka government made that more than some lakhs together people were claiming Grihalakshmi scheme. Some must have died, there is no address, and they are economically strong, their tax assessors and everything they were taking. Now they have been stopped that. So this database, death and birth certificate, creation of database is there under the Registration of Births and Deaths Act. And it is the mandatory, and it's a part of every citizen of the country. Then protection of public servants. Yes, many of you are government servants, and for all practical purposes, government servants are protected under the law. See, in any administration, in any system, the constitution play important role. I have in the initial classes I have told you the importance of the constitution as far as Watson law hierarchy concerned. Indian context, the constitution prevails over other acts or laws. So like that, Article 309 to 305 to 311, it mentions about the service conditions, how the state has to provide service conditions, recruitment rules, disciplinary powers, everything it has been mentioned in the Constitution. And as per Article 311 of the Indian Constitution, the person who has appointed you, not selected, appointed you, have only power to dismiss you from the services. And no person should be removed from the services without giving any adequate and reasonable opportunities. Therefore, to remove any government servant from the office, they must conduct departmental inquiries. How the inquiry should be conducted? That is mentioned in KCSR. In KCSR, you have CCA rules, cadre classification and appellate rules. According to that rule, the inquiry should be conducted. There are good number of systems, what the charge sheet has to be done, how the cross examination chief has to be done, how the cross examination has to be done, what is the defense and all, what are the evidence is mentioned in the CCA, that is a part. Then protection for lower authorities. As I told you, the punishing authority, removal authority must not be below the rank of the authority who has appointed. And lower authorities are delegated with some power. They can award minor punishment. And right to fair inquiry. Article 311 says that they must be given adequate opportunities. And one more thing I want to share with you. Article 20 of Indian Constitution say that a person must not be punished 2 times for the same offense. So I want to share one example with you. Normally, I take the driver example. My driver drives and make an accident. and he go to the court, police also book a case against him. The court declare him as acquitted. Whether the KSRTC can conduct inquiries and remove him services? Yes, because the state, the police book a case against the driver because he is trying to kill the person as per Indian Penal Code. Homicide is punishable offense under the law, and he has to prove that he is innocent while driving the or injuring the particular person. But the question is, as I told you, Article 20 of the Indian Constitution, it is called double jeopardize. So two punishment must not be given for one mistake. In that, the corporation or KSRTC charges him for having committed damage to the bus, and the bus was stranded in police station for so many days and it was not available for operation. And in addition to that, the KSRTC is asked to give compensation. So they charge for having committed offense against the corporation. Therefore, this concept, double jeopardize, do not apply in case of the Article 20. So therefore, whenever you are driving a vehicle, police book a case against you. Even your department also can issue a charge sheet, right? So under such circumstances, you must prove that it is not my fault and all. And there is some cases also, if the charge sheet and police charge sheet are same, if one is acquitted, other also be acquitted, like that, that is there. That is secondary. Then we can see in the other CCA rules and all, we can study there. Then the legal protection, prior sanction for prosecution. Under 197 of the Criminal Procedure Code, public servant cannot be prosecuted in a criminal court for acts committed in the line of duty without prior sanction from the competent government authority. See, for example, I tell you, Tahsildar and Assistant Commissioner and Deputy Commissioner take numerous decisions in criminal cases also. For each and every case cannot be booked against them because they are taking in good faith under Section 197 of CRPC. So they cannot be punished for that. So that is the protection. Therefore, IAS and IPS officers claim or as if they are above the laws. So sometimes they misuse, but you cannot question. You can question that action in the court of law, but you cannot hold him responsible. I want to quote an example. Suppose one officer, say principal, he'll dismiss one employee from the services. The employee is reinstated through the court. Whether the principal must be punished? No. As I told you, three things cannot be questioned. One is the discretion of a judge. As a principal, he has acted as a judge. So if at all the person has affected with his judgment or his discretion, he can go to the appeal, he can go to the court and get reinstated. For having exercised the disciplinary powers, he must not be punished. Like that, this is a protection given to the government servants under the law. So immunity from civil suits. Numerous specifics enactment like public examination, certain explicit causes stating that no civil prosecution or other legal proceedings shall lie against the public servant for anything done in good faith while exercising their official functions. This normally happens in land disputes. What happens? The village accountants or revenue inspectors, they do whatever they want. And they write wrong things also. So they cannot be, the suits cannot be filed against them. For that, you have to appeal to the next higher authorities to quash the decision he has taken. So that is the only remedy available. Under the circumstances, protection of public servant is there under the article and also Criminal Procedure Code. Indian courts have continually reaffirmed that public servants performing official duties cannot be targeted unless explicit malice, illegality, or gross negligence is proven. Now the question arises, when person is doing the work, for example, you are engaging the classes, so somebody else come and disturb you. It is punishable under Criminal Procedure Code 8068. They cannot disturb you while you are engaging the classes. Let him be anybody. except students can ask you the questions, but no third person come and disturb you. And it is punishable offense under the law as far as teaching profession is concerned. What happens when in other government departments, they are doing some work. So they come for survey of the land. The people will come with rowdyism. They will not allow them to conduct the survey. For that, they will be arrested and they will be punished. See, protection for the government servants. Punitive protections against the obstructions. While government servants are required to be courteous and responsive under central civil rules and conduct rule, in punishable offense for citizens outside forces obstruct them. Whoever obstruct them, any government servants. And for your information, especially all India cadre services, especially all India, the IAS, IPS, IAS, IRS, all these people are protected. From whom? President of India. State cannot take any disciplinary action against them. What they can do is they can reprieve them. You take your officer back to central government. We don't want his services like that, they say. Therefore, they are very strong. Because in the training they have been trained like that. They are told that you are God on the earth, especially IAS officers. They are told, they are given training that where is God? You are the God, you are the government. You take decisions. And whatever the decisions they take, they stand by it and justify it. That is the beauty of the cadre of IAS and all India level services. And Indian Penal Code, earlier it was Indian Penal Code, now it is Bharatiya Nyaya Sanhita. Under section 221, anyone who voluntarily obstruct public servant to discharge their public functions faces imprisonment. Suppose you go for the election duty and you go for census and other work. If anybody obstruct it, it is punishable offense. Then Whistleblowers Protection Act. There is also an act called Whistleblowers Protection Act that the protect government servants if corruption, misuse of power within the department taking place, retaliation. If anybody inform the government or the particular department, they must not be punished. There is a provision under the law that is called Whistleblowers Protection Act. But practically, I don't know whether it is successful or not. But there is an act. Whoever have that courage to question the illegal activities of the department, they can give in writing to the concerned department head and they will take the action. Then protection of public servants, important conditions in good faith. If you have done the work in good faith, it is fine. They will protect. Not the good faith, they have numerous this one. There not be any ulterior motive and all. If they claim that I was doing in good faith and all, and you must not take the decision beyond your control. One cannot take the powers beyond his control. He don't have power, he cannot exercise the power. Like that he has to do. Then rights of arrested person. If a person is arrested, what right he is having? Then right to be informed. Immediately after his arrest, the person, he must be informed under what circumstances he has been arrested. And the grounds or on what grounds he has been arrested. And he is permitted to, he has a right to consult his legal counsel. Then remain, and when it is this one, remain silent, you are protected against self-incrimination. And police cannot force you to tell you that I have committed a mistake. And whatever statement taken by the police can be questioned in the court of law, and that is not an evidence at all. If you go to the court, tell before the judge, sir, this police beaten me like anything, therefore I have agreed. Then I have committed the mistake. Then judge will say, yes, whatever he says is correct, police is wrong. You prove it. Like it says. So then produce before the IAS. It is mandatory on the police to produce the particular person within 24 hours. When they arrest, they produce him within 24 hours. Normally what happens, they will not show that they have arrested. Okay, they will just ask the particular person to come and sit in the police station. They will not show that the person has been arrested, and they will shift him to some other police station. When they bring the warrant to relieve him or bail to get him released, they will shift him to some other police station. Once again, they have to run to the other police station. Therefore, the advocate who come to know that the particular person has been arrested and is in the bail, immediately he has to rush and prepare a document and submit a copy to the police that I'm filing the case before the court for bail, you be ready. Then they will not change. Otherwise, they will go on changing. The police are obliged to inform you, yes, they must say what are your rights and all. Notify friend, you can contact the friend and all. Even before arresting, the police will conduct the medical examination, whether he is physically fit and he need any treatment and all, it is done. So maintenance of welfare and parents and senior citizen act, it is after 2007 it has come. Every senior citizen who is above 60 years of age have a right to be maintained. Maintained by whom? Their children, even grandchildren and relatives. And whoever are enjoying their properties. Nowadays, good number of cases keeping the parents in the vruddashrama or kicking them out, making them to be on the street. Recently was happened one Raymond or some company owner was made to walk in the street, who is a rich person. So the Maintenance Welfare Act is there. And for this, assistant commissioner is the tribunal head. He will give the judgment. And what they can do, they need not have to hire any advocate. Just in the plain paper, if they write, not necessarily that senior citizen must write. Any person on his behalf can write a complaint to the assistant commissioner that this person is treated not properly. Therefore, you are requested to take the decision in this regard. Immediately after that, the assistant commissioner can order for maintenance amount. Every month he has to pay. And if at all the person who got the order for maintenance is want to appeal, he must deposit that amount in the assistant commissioner office and go to the court, not otherwise. So senior citizens are treated with this act. They have obtained some rights to be there in the property. Anybody offenses or fail to comply tribunals, they have to pay the fine and also imprisonment. Then protection of life and property. The senior citizen can ask the children to vacate the house. Not necessarily they must give in writing. Mere their statement is sufficient to kick the children or anybody who is occupying their house out of the house. And if the property is in their name, and whoever is occupied, children, daughter, son-in-law, mother, the daughter-in-law, everybody, they are only licensees. They are not tenants. Licensees must vacate the house mere by word. And there is no necessity that they must prove that they are not taking care and all. They may go and tell that we are taking care of them. No. If the senior citizens say that they are not taking care of him, that is the final. There is no evidence for that. So recently, and a good number of judgments are there. So even I handled one case. A daughter filed a case against the mother for adverse possession. She has been asked to stay in the mother's house for 20 years. She went and told before the judge that, sir, I am there in the house for 20 years. That house become mine. Then I questioned, see, if the children staying in the parents' house become adverse possession, then what is the fate of the senior citizen? They will be in the streets. Then court gave a judgment in my client's favor. Now they have been vacated. So they must not be abandoned senior citizens. They must be given due care. All this, even Vruddashrama's establishment also it is there in the Senior Citizen Welfare Act. Prevention of Sexual Harassment Act. Yes, it is the Vishaka versus State of Rajasthan under public interest litigation. In every government organization or in private organization, where more than 50 employees are employed, there must be a internal consultation committee. And any grievances, lady grievances of harassment will be presented before them. If the committee give a report and the employee will be punished under the law and also he will be taken, disciplinary action will be taken against him, both. Here, as I told you, Article 20 of jeopardize, double jeopardize. He will be punished departmentally and he will be put behind bars. And he will be asked to give the penalty amount to the suppressed. Then what are the type of sexual harassment it is there? Unwelcome actions, showing pornography and all, they are there. You can go through this one because the time is short. I have to cover other this one. So recently I had a case. One lady complaint against a person in the verge of retirement that he sexually harassed. Then the committee gave a report, and it is not done. And for your kind information, anybody give false complaint, that lady is punishable under the law. She will also undergo the punishment, and she will also entitled for departmental inquiry. Therefore, while making a complaint, one must be very careful. Not necessarily that all are prone to this one, all are like that. But certainly, the ladies are prone to assaults. It may be physical, mental, economical, cultural, and all. Probably, therefore, Muhammad Paigambar allowed in Islam religion to marry more than 4 people. But I feel, as for my knowledge, little bit knowledge about Islam, they can marry either divorcee or widow, not a virgin girl. So probably it is like that. Anyway, the sexual harassment is possible. Therefore, the act has been passed, Vishaka versus State of Rajasthan case. That is because of that public interest litigation, this act came into existence. If there is no internal committees, the deputy commissioners, taluka level committees, and assistant commissioner constitute the committee. And one NGO is compulsorily involved in that. One NGO must be there in the committee because they will value this one. They will also guide how this harassment can be prevented. So sexual, this one, penalties for offenses, written apology, warning, then monetary compensation also is given. Then punishment for false complaint under section, as I told you, under section 14, the punishment is also there for filing a false complaint. That must be proved. So preconception and prenatal diagnostic techniques. Yeah, this is about identifying the gender before birth. And it is completely prohibited any nursing homes or any institutions, any person involving in that identifying the gender of before birth baby is prohibited. They cannot do that. But however, on some circumstances, that if the fetus is not healthy, is going to be physically challenged or mentally challenged, and if there is some genetic disorders, and that has to be properly proved, and then permission must be obtained to give it is not identifying the sex, it is only termination of the pregnancy. So mandatory registration, every offering prenatal diagnostic technique must formally register under the Act and maintain detailed accessible records of all procedures. Normally, some of the hospitals involve themselves in identifying or detecting the sex of the fetus, and some of them have been arrested and some of them have been closed also. So Dowry Prohibition Act, now it seems this act is becoming obsolete because the women empowerment and nowadays, earlier people used to say we must get good groom. Now the parents are thinking we must also get good bride also. So therefore, dowry is prohibited under the Indian context. That imprisonment is there. And for dowry case, if it is more than 7 years, they cannot file a case for the dowry this one. Before 7 years, they can file a case. And even there are Hindu Marriage Act, there are diverse applications also can be filed. Even Islam law also, there is a provision to file the diverse case. And Christianity and minority religions like Sikh, Jain, they also, the Indian Hindu Marriage Act is followed in that circumstances. So Dowry Prevention Act is also, Prohibition Act is there. Protection of women from domestic violence. Especially the women, it is passed in the 2005, especially after marriage, the lady must be properly treated in the in-laws house. Physical abuse, then sexual abuse, then emotional abuse, These are all considered as domestic violence. Then economic abuse, forcing them to bring the money or giving them the minimum requirements. Then allowing them to stay in the house, making them to sleep outside and all. Dowry harassment is also known as domestic violence. So there is a protection, and the authorities are there. They will come and make that particular ladies to stay in the house. It is the responsibility of the head of the house to provide all protection to the lady under Domestic Violence Act. So residence orders guarantees woman right to reside in shared household regarding her legal interest in the property. It can also order for abuser to vacate the premises. Whoever abuses, he will be asked to vacate the house. Monetary relief is given. Then compensation and damages, if any, this one is torture is done. Then custody orders. So temporary custody of children of aggrieved person is also ordered under the Domestic Violence Act. So key parts, any woman who is or has been domestic relationship include live relationship with the abuser. See, nobody can this one file case unless is a woman who is staying with him. Response can be sought against husband, his relatives, adult male, female member, shared household. Protection of officers, government appointed officers with assist the victim in filing complaints, drafting applications, and this one court filing can be done. Then Right to Information Act. So it is very important, is fully abused. Then I underwent training in the National School of Law University in Nagarbavi. It was in the year 2005 when it was enacted. During that period, I was working as a depot manager. Then I asked one question. Sir, have you heard there are blue books in Indian administration? No. There are blue books. They are printed, not published. Right? Under Official Secrecy Act, it comes. I asked two questions. Any information taken can be produced in the court of law? Yes, you can produce it in the court of law as an evidence. And blue books, whether we can take the copy of the blue books? Yes, you can take the copy of the blue books, but they cannot be administered. The judge cannot take decision on that as per your pleadings. See, what is that case? I want to share one very, very important case. You must have heard Raj Narayan. I don't know. He is the person who contested against Srimati Indira Gandhi and won the election. Rai Bareli. Right? He made a complaint before the Supreme Court that Prime Minister of India, Mrs. Indira Gandhi, has used 32 jeeps of government vehicles for election campaign. He filed a case. The prosecution, the government advocate came and pleaded that, yes, sir, we have made arrangement not to Mrs. Indira Gandhi, President of the Congress. We have made arrangement as a Prime Minister of India. She visited Uttar Pradesh for her security, safety, and everything. We have made use of the jeeps. The case was dismissed. See why the blue books are those books. They will tell you what to be followed when the President of India goes to a particular place. When the vice or any government servants like vice president, president, governor, prime minister, anybody, or even some ministers or some kings come from outside, what arrangement should be done and how administration should be done. It is all mentioned in the blue books. Judge can read it, but he cannot take it as an evidence. Okay, then Right to Information Act, now we come. It is an act provided you can ask any information, but you cannot ask any information which is under process. Suppose a tender is going on for particular construction of a bridge. You cannot ask for the documents who has quoted what. But you can ask after that. After process, you can ask. And you cannot ask who is setting the question paper and let him share copy of the question paper. No, it cannot be. It is exempted. You cannot. It will not be given. So like that. And some secret things cannot be shared under the Public Information Act. And anything which is going to harm the society, that information should not be shared. And for example, if I don't like one particular person, I want to file an application under the Public Interest, this Right to Information Act. What is his earnings? how much income tax he is paying, what salary he is getting, you cannot ask unless that particular person agrees to give you. So like that Right to Information Act is there, it is a weapon, it is used and abused also. Here also there are different layers. In any offices, there must be a public information officer, PIO. And it is his responsibility to provide the information. And for that, there is a pro forma, and you have to pay 10 rupees postal order, or 10 rupee cash, or 10 rupee challan. Whatever you will get the information. And they can charge you for sharing the information. 2 rupees per page, or 1 rupee per page, the stationery cost and all. You have to pay and take the information. However, if the person is below poverty line, he need not to pay the money. So what if the PIO don't give information? The government officers must make a mention that if the PIO don't give the information, who has to be contacted? They will make a mention of appellate authority. You can appeal before the authority in the same office. Even appellate authority don't give, you can go to the district forum, then state forum, then national forum. So this is the procedure involved in the Right to Information Act. And you cannot ask for the process. You cannot ask the information, what you are doing. No. You can ask copy of the information. You have taken decision like that. What is the copy of the order? But you cannot ask the process. Asking process is prohibited. And if the information is not given, the commission can order for penalty up to 25,000 rupees, right? And also the departments can initiate disciplinary action, and they cannot ask the person to consolidate it and give it to you. They cannot ask how many this one amount you have spent and who are all sent. No, available information. You need not have to spend extra time on consolidating the information. You merely say that this is the information available with us. You here please find here enclosed with, take the copy of this. But they cannot ask you to consolidate, codify it, generate report, and you know, it is none of PIO's business. He can say, and if he's aggrieved, but that's one, he can go to the appeal and he can go to the commission, and the commission also will treat like that. So this is the Right to Information Act given under this one. It is used and abused also. Yeah. Asking anybody any question? The time is over. Huh? Hello, I'm not hearing you. Who is asking? Sumalata?
Yes, sir.
Yarak one prashna ಕೇಳ್ತಾರೆ. So, yeah, now Right to Information Act and legal aid services. I'll finish it off within a few minutes, and you can go for questions. Legal aid services are there. Free legal aid, legal services authority is there, and all the central government and state government have established legal services authority, and you can have a free legal aid. Women, child, then SC/ST, industrial workman, victim of trafficking, then violence, and then atrocity, person with disabilities and mental illness, an individual whose income is less than 3 lakh rupees per annum is entitled to free legal aid. Then legal services, Karnataka State Legal Services, district level legal services are there. High Court legal services are there. Alternative specialized aids are also there in demands. Then there are some advocates who want to make services to the society free of cost. They are also there. Then you can see free law advocates in Karnataka. That also you can make use of whoever wants in need. So free legal aid services. Okay. So this is about the legal system and important facts, guys. So if you have any questions, one or two, or otherwise you can collect my information from the institute and you can keep in touch with me. I am expert in the field of service matters. Any?
Excuse me, sir. Sir, I have one question.
Please.
Sir, what is the difference between a general